Rav Willig, thank you so much for making some time to learn with us today. Rav Willig is a Rebbe, a posek, and advisor to many in the RCA. Of course, Rosh Yeshiva at Reitz as well. He's the Rabbi of the Young Israel of Riverdale, Skan of Beis Din of the Beis Din of America, author of the RCA's prenuptial agreement, and as well Rosh Kollel at Morash's Kollel. So it's a big honor, it's a big cover to have the Rosh Yeshiva here today. And please, the floor is yours. Thank you.
Thank you very much. Moreover, Rabosai, I was asked to speak about a very important topic. Given the limited time that I'm given, I'll try to speak rather quickly and cover as many of the topics that are relevant as I possibly can. The topic is, what must a local Rav in a shul know about Beis Din in terms of how he conducts himself, in terms of how he advises his balabatim? This is the topic. So number one on the agenda is to explain to balabatim that there exists an Easter of our cause. There's a prohibition of going to a secular court. That means if a person has a claim against another member of Klal Yisrael, it's supposed to be adjudicated in a Beis Din, not in a secular court. I assume you're familiar with the first Rashi in the Parshas Mishpatim, Lifnei v'lo of the Avodah Zarah. You're not supposed to go to a secular court. The Shulchan Aruch and Siman Chavav and the Choshen Mishpah is very, very strong language from the Rambam and others. It's a Beirim Yad B'Toras Moshe Rabbeinu. It's a bad thing to do. And therefore, if your Balabas says, have a case against another Jew, call him into Beis Din. Call him to Beis Din. I'm partial towards our Beis Din, the Beis Din of America, affiliated with the Rabbinical Council of America. Ask him to come to Beis Din. What'll happen? He refuses to go. He won't go to any Beis Din. I'm not going to any Beis Din. I absolutely refuse to go to Beis Din. What can you do? In some cases, the Beis Din, our Beis Din or a different Beis Din, will issue what is called a heter hakos, a dispensation to allow an individual who has no other recourse because the defendant refuses to come to Beis Din to pursue his case in a secular court. This is true in such a circumstance. There could be other circumstances in which, even though the defendant is willing to go to a Beis Din, the Beis Din can't get the job done. I'll give an example. A situation where there is an insurance company that's the real defendant is the insurance company, a non-Jewish insurance company, and they may decide, wisely or unwisely, they're not going to honor a decision of an arbitration panel such as a Beis Din. They insist on going to a secular court. The only way for the plaintiff to receive anything if he goes to secular court, so the defendant's non-Jewish insurance policy will pay. In such circumstances, often a Beis Din can give a heter hakos, even though the defendant wants to go to Beis Din, because Beis Din simply can't do the job. I refer you to a beautiful article by Rabbi Yaakov Feit in the Journal of the Beis Din of America, #1, about this and many other relevant topics to today's discussion. And once I'm recommending the new beautiful series called Jewish Prudence, a nice pun, edited by Rabbi Itamar Rosenzweig. Also wonderful things there which relate to what we'll be discussing today. Okay. Now, once Beis Din issues a psak, our Beis Din and other recognize what they did, we assume that the psak is correct. And the rabbi must maintain that posture, notwithstanding the fact that a parishioner of his who lost the case comes complaining to say it's terrible, and he can get his friends to say it's terrible. He can even get certain rabbis to say it's terrible. All this is irrelevant. The assumption is that the Beis Din got it right, not merely because we believe Elokim Nisaba Daskel Siyata D'Shmaya, but they're a neutral party. Remember, everybody who's complaining to you as a rabbi is not neutral. It's either the person who lost, or his friends, or his rabbi friends, but they're not neutral. The Beis Din is totally neutral. Certainly in our Beis Din is total neutrality. Any possible conflict is disclosed in advance, and therefore the assumption is that the Beis Din got it right, even though it seems to you, based on what he tells you, it can't be right. Believe me, the Bezdin heard both sides and got it right. Okay. Sometimes, as we mentioned earlier, a person will refuse to come to a din Torah. Refuse comes to Bezdin. So we spoke earlier about a heter arkos, a dispensation to go to pursue the case in secular court. Once in a while, that's not the main point. The main point is he refuses to come. You're not supposed to refuse to come. When someone refuses to come, he's what's called a sarvan, and Bezdin can issue what we call a shtar siruf, which means basically it's a contempt citation. He was summoned to Bezdin and he did not come. He did not come. And therefore, he didn't come. So what do you do with him? So this is a very serious question, what you do with him. And there are different approaches given by different rabbanim in different circumstances. And our business policy, as a rule, is we leave this to the discretion of the local Rav. The Rav has many options. He can say the person is not allowed to come to shul. He can say he can come to shul, he won't get an aliyah. He can say, don't talk to him, don't invite him for Shabbos meals, whatever. He can say what he wants. It's up to the rabbi's discretion as to how to enforce or really not enforce a siruf. A bezdin can make a proper objective decision that the individual is wrong by not coming to a din Torah. But the rabbi who knows the personal circumstances may realize maybe he's not so wrong, maybe there are extenuating circumstances. So it's up to the rabbi in his own shul to decide what the shul's policy to be towards such an individual. An exception to this rule is a case of aguna. In aguna, there are specific rules which have been promulgated a long time ago by Rabbeinu Tam, known as Harchokos to Rabbeinu Tam, which a bezdin can in fact set out what they are. Specifically, no one should do him any favors, no one should do business with him, and it can extend. He shouldn't come to shul. He shouldn't get an aliyah, as the case may be. Every case is somewhat different, and the rabbi has to figure out how to approach it. This is what's called harchokos to Rabbeinu Tam. Ideally, these harchokos should be issued by a bezdin, a proper bezdin, because the bezdin has to have jurisdiction of some sort to be able to issue this in a perfectly appropriate fashion. However, let's say these types of restrictions of Rabbeinu Tam were put into place without a psak of the bezdin, it does not render the get issued upon this circumstance to be invalid. That's a psak l'halacha. It's a long discussion. Someone decides, a group decides that we're going to try to take measures to get him to give the get, and they really had no official authority. There was no psak of a bezdin. Nonetheless, whether it was right or wrong in the first place, a get given in the shadow of such activity would be a kosher get. And once again, every Rav has the opportunity, and in some cases perhaps a responsibility, to make such requests of his people, not to do favors for such an individual. If he, the Rav, feels that this fellow is being ma'agen, that means he's not giving his wife a get in a case in which the get is warranted. Not every case is warranted. But if it's warranted according to the rabbi's judgment, and he's not doing it, the rabbi has a right to say, we don't want you to come to shul till you give your wife a get. Now there's been a new phenomenon called protests. It started with a group called ORA, the Organization for the Resolution of Agunos, and more recently there's been a few, forgive the expression, vigilante groups that without any, ORA always works with the bezdin. These other groups, it started on social media. There was a recent psak of a rabbi in Muncie that a bezdin may permit people to use social media in such cases to encourage someone to give a get. This is notwithstanding the fact that in that part of the town, social media is trained. But for this purpose, apparently those who are using it anyway may use it for a proper goal. But getting back to our discussion, in such a circumstance, we can say that the rabbi can say protest is appropriate. Again, if there was a siruf against the fellow, it's much better. Even in that case, ideally, the protest should be that he's a misarif. He's not coming to bezdin, because we know no one knows for sure is he really obligated to give a get. But in other cases, we won't even come to bezdin, and some of the bezdin will not issue a siruf for various technical reasons. But the bezdin tells the local rabbi, in its opinion, a get should be forthcoming at this point, based on what it understands. It's not a formal psak. They haven't heard both sides. The guy doesn't want to come, and there's no sira because he, various reasons, which we'll get to. Nonetheless, the rabbi has the right to issue these kinds of harchokos, stay away from this fellow, and he's permitted to have protest the husband, and this can, fortunately, in some cases, yield a get. Not all cases. It's important to know that no one should go beyond what's permissible. What's not permissible is beating somebody up, excommunicating him, stealing his money. All those situations might lead to an invalid get. So you have to be very careful. The halacha l'maisa, if you just cease and desist from doing him favors, that's probably in a time fundamentally. And even if that's causing what we call embarrassment, and according to one version of a Rashba, it's a problem. The halacha, it's not a problem. It's probably not even the correct text in the Rashba. So these kinds of achokos will not yield a invalid get, even in a case in which perhaps it shouldn't have been invoked in the first place. It's up to the discretion of the local rav in such circumstances. Now, to avoid all of these things, every rav in his community should encourage the use of the prenuptial agreement, to which it was referred in the introduction, which is sponsored by the Bezdin of America, the Rabbinical Council of America. It's a very effective tool. It doesn't work 100% of the time, but it's very effective. And everyone should encourage their balabatim when they're getting married, marrying off their children, that this should be signed. It should be signed. It's also worthwhile, very worthwhile, that within the standard prenuptial agreement, there's one part which is optional. And the option is the entire dispute given over to the Bezdin's jurisdiction, or in the more limited sense, the Bezdin is only empowered and authorized to deal with the issues of the get, what we call get timing, when it should be issued, and the tnoim and the ksuba, but not necessarily authorized to deal with other issues which may come up. I strongly encourage that the more robust form be signed, where the Bezdin is given the ability to deal with all matters. Yes, in straight financial matters, what they do is automatically accepted by the secular court, with the rare exception of fraud or irrationality. One of my rulings was viewed irrational by a claimant, but it was taken to secular court, and the judge said it was not only was it not irrational, it was very rational and very right. And that was a very important psak way back in the state of Maryland some years back. In any event, this is what should be done. This way, you're not going to get involved in the secular court. It is true, full disclosure, it is true that, at least in theory, any decision offered by any arbitration panel in matters of child custody, visitation, support can be overturned by any state court which views itself as a protector of children. That is true technically. In our many years, our business was reconstituted in the later 90s. We've had many, many cases. To my knowledge, we've yet to be overturned by any court in any state on such matters. And the reason is we pick top flight people. I'm happy to say that when we have custody issues, we try our best to get the services of Dr. David Pelkovitz, who's a nationally known, internationally known expert in the field. Unlikely that the court's going to second guess what he has to say. At least so far, that's been the case. We can't guarantee what's going to happen in the future. Okay, now what happens if a member of your congregation was summoned to secular court? It's not his initiative. He's summoned to secular court. The best piece of advice you can give him is to come to the Bezdin of America and immediately summon the person who's summoning him to come to the Bezdin of America to have it adjudicated. You'll say it's an exercise of futility. He took me to court, not to Bezdin. It's not futility, because if you say you want to come to a Bezdin and he refuses, and it goes to a secular court, and you win, now he's going to wake up, oh, I want to come to Bezdin, I want a second bite at the apple. Or a claim can be made, all right, you won, but the money you have is ill-gotten gains, because according to Din Torah, wouldn't belong to you. Those are two possibilities which can be daunting. My view is that if you said explicitly that you want to go to Bezdin, it may be true even if it's implicit, but it's always better to make things explicit. Then, if you happen to win, the money belongs to you, even if it would not have belonged to you according to the Torah. That's my opinion. Not everyone agrees to that. And therefore, it's very important, I believe, to say so explicitly, contact the Bezdin, issue a summons. He's not going to want it. Okay. So then obviously you can go to secular court. The only heter cause for a defendant, he's dragged into court. But in order that should not be said, oh, you accepted the court's ruling on your own also. You can't come back and say you want a Bezdin. No, you say from the beginning you want Bezdin, and then you're in a better situation going forward. If it's made explicit that you want to go to the Bezdin, he'll likely refuse, puts you in a better situation. If you look in the Ramah, in Siman Chavav Sif Aleph, that once the case proceeds in secular court and the other guy sees he's losing, oh, he becomes a Baal Tshuva. He wants to come to Bezdin, ain't his kokolo. Bezdin will not deal with him. It's important for that point and for the point that if you win, the money should belong to you rightfully, that you express at the beginning, ideally by having a formal hazmana summons to the Bezdin of America or a different Bezdin. And perhaps even if it's informal, you tell the rabbi, I want to go to Bezdin, tell him to go to Bezdin. The rabbi speaks to him and he says, no, that would also be likely be effective for this purpose, but not as good. Let's continue. It seems to me it's a very worthwhile piece of advice to your parishioners, your balabatim, as follows. Whenever they sign a contract in any business matter, they should write into the contract that in the case of a dispute, the dispute will be resolved by the Bezdin of America. This solves many problems. The person will want to take it to secular court. Sorry, Bezdin of America. The person will want to take it to a disreputable Bezdin. Sorry, says Bezdin of America. It's a very, very valuable piece if you're looking to have an honest resolution of a dispute, which you can't even envision dispute. Right now, your best friends, like a husband and wife, your best friend with the business partner. But you never know what's going to happen down the road. You never know. We can't predict the future. The best way to be insured against hanky-panky is if you write into the original document of agreement that if there's a dispute, it will go to the Bezdin of America. And mind you, this is an important note, certainly according to our Bezdin, it's permissible to write into that original document that if there'll be a dispute, you would like the dispute to be resolved by the Bezdin of America in accordance with a particular law. It could be the law of a state, a law of a country, a law of a city, or any other type of law, uniform commercial code, whatever. And at least in our opinion, our Bezdin, there's nothing wrong with doing so and having the Bezdin itself hear the case, but instead of invoking pure Shulchan Aruch Choshen Mishpat, they will invoke as well secular laws which the parties in advance agreed upon to be binding. Now, this is not the same if they agree upon it at the very end after they have a dispute. That's a much bigger problem. But if this can be found in Rabbi Feit's piece as well, I believe. If they agree from the very beginning, we believe that it's binding and it's valid and it's okay based on the general rule of Kol Tanai Shebabam and Kayim. This is a psak of Rav Zalman Nehemiah Goldberg Zechet Tzadik Levracha in Yeshurun. I have a piece about it in my own sefer, Am Mordechai, on the Aleph Chak Shulchan Aruch, on page Resh Ayin Aleph and Beis, that this works. Some disagree, but this is the psak of our Bezdin. And so therefore, it's certainly worthwhile, I believe, anytime you have a business agreement, any type, you're signing a document, a contract, put in a provision for arbitration. It's very common. They'll put in American Arbitration Association, or they'll say the state of this, the state of that. The state of this or the state of that the court should hear it. That's an Yisrael cause. You're not supposed to do that. According to the psak that we have, not everyone agrees. Even if both parties agree, you can't do that. That's a merim yad b'toras Moshe Rabbeinu, as if to say that the system of the Nachrim is superior to the system of the Torah. That's macro. However, if you are going to go to a Bezdin and you'd like that the Bezdin should rule in the case based upon particular law, that's only a particular law, a local law. It's called Tanai Shabbat Kayim. Reuben and Shimon can make any condition to govern their financial relationship. So the laws of the state of New York is no different as we pass in Allah, as I told you, even though not everybody agrees on this point. Okay, having said that, what happens? He didn't write it. And you are summoned now to a different Bezdin. A different Bezdin. What do you do? I believe the proper advice to give to your member is to write back to the Bezdin that summoned, I want to go to the Bezdin of America. That's where I want to go. The Bezdin of America. That's my choice. Now, what happens? He chooses Bezdin X, you choose Bezdin of America. What happens then? It's something called a Zabla. Ze Bora Lo Echad. Each side picks one judge, and the two judges pick a third judge. And this is an ideal system when it works. When it works. In today's world, it often does not work. I'll explain momentarily why it does not work. Unfortunately, very often, a person will choose as his borer, Zeb Borer Lo Echad, the one that he chooses, an individual who is not of the best reputation. Either he's known to have been dishonest in certain cases, or he's known to take bribes. Included in that, at least in my view, is a situation in which a judge involves himself in what we call today ex parte communication. He speaks to the party that chose him without the other party and the other dayanim being there. This is an absolute no-no from the perspective of strict halacha, even from the perspective of secular law. Unfortunately, it goes on all the time. The Aruch HaShulchan bemoans that fact. He says, look, if all the parties waive this problem, they say it's okay for everyone to speak ex parte, then the judgment is valid. But not if you didn't waive it. And unfortunately, people just do these things all the time, and it's a problem, a very serious problem. It might invalidate it both according to Jewish law and according to secular law. What makes it worse is that you have cases, and I'm speaking from first-hand experience, where even otherwise reputable rabbis will sit as what we call a borer, a judge on one side of the issue, and they will have conversations with the party that chose them, which is against the halacha, and they'll charge by the hour for those conversations. To my mind, that's called shochat. That's called bribery. I think that's such a dayan is puzzle. Take a look at that same sefer of mine on page Reish Samach Gimel. I think it's an unfortunately common phenomenon, but I think such a dayan is simply not a kosher judge. He's taking shochat. That's what I think. Now, back. So you go to his Abla. If he picks a bezdin or a judge that you feel is not appropriate, refuse to go. So you pick your dayan. He'll pick his dayan, and then they'll pick a third. But the guy's going to pick a bunch of people who are not honest. At the end of the day, refuse. Don't ever go to a din Torah to your balabatim where the odds are stacked against you because the other party or the other side is exercising his right to choose a third, the neutral dayan, but everyone he chooses is someone who cannot be trusted. At the end of the day, refuse. The Nesivus writes in such a case where they cannot agree that the nitva wins, the defendant wins. It's true, you may get slapped with a siruf. The Bezdin HaMazmin that issued the original summons to you, you said, I don't want to go to you, I'll go to a different Bezdin, and we'll have a zablo, things of this nature. And then when the other guy keeps getting 1, 2, 3, 4, 5, 6, 7 judges, and you think the judges are not really good, then they may say, sorry, you don't have such a right, we'll send a siruf against you. Okay, I believe the rabbi should not enforce that siruf in any way, because the person is entitled to a fair judgment. He's entitled in principle to a judgment which has no ex parte communication. And that's very hard to manage with people who are well known to be engaged in ex parte communication on a regular basis. They're not even credible if they say that they're not doing it in this particular case. So therefore, that don't go. Take the siyuv, as we say, if it comes, and the rabbi should tell the people, listen, this siyuv is not legitimate, because he wouldn't pick another legitimate bezin to go to, a dayan to go to, in this particular case. What happens, however, if your balabas is a toveya, is a plaintiff? Now the jig is up. Toveya, what are you going to do? You have no choice but to go to Zabla, otherwise you lose the money. The Zabla, you stand a chance. Well, not 100% true. If the other side picks a rabbi or a bezdin that's so egregious, whose reputation is so low for dishonesty, then on occasion, this plaintiff can go to a bezdin or to a rav and say, this is impossible. I can't deal with this guy. He's not honest. A bezdin may in such a case issue, rarely, but can happen, a heter hakos. That means you, Ruvain, have a right to pursue the case in court. Why? Because you wanted a good bezdin. He wanted a not good bezdin. So you had to have zabla. You picked a good rabbi. He picks a not such good rabbi. But who's the third? So the third, you can't get a decent rabbi because the not good rabbi on the other side only wants someone like him who's not so honest. In that case, if a bezdin is convinced that no valid, fair alternative was granted to the plaintiff, they may issue heter hakos. He won't go to any bezdin which is a decent bezdin. So there's such a thing may be issued in certain circumstances. Okay, now it's very important to note that our bezdin is different than all other bate din in this country, just about, perhaps one exception in Muncie. We do not allow toanim. And the word toanim is a dirty word, as it should be. Toanim are literally rabbinic pleaders. And unfortunately, there's simply no code of ethics governing them. None. The more unethical the person is, the greater price he commands. Because he'll do anything to make sure his client wins. No holds barred. And therefore, there are very, unethical toanim floating around. But except for us, and maybe one other bezdin, I think, no one else excludes them. We exclude toanim. We, of course, allow lawyers. Not for what? Two reasons. Number one, if you don't allow lawyers, the case can be overturned by any sake of the court because you have to have the right to counsel. And we have a very serious shtar birurin, a standard form of document arbitration, which has to be signed going into the case. And we spell everything out to make it as enforceable as possible. Disallowing an attorney, by definition, makes it not enforceable if it's not waived. Number two, lawyers have a code of ethics. They can be disbarred. And therefore, they're not so ready to engage in unethical practices in defending a client, no matter how much they're paid. And therefore, they have a better chance of the proceedings going smoothly. Sadly to say, there's a lawyer there, even though the Toain knows more halacha, obviously, but the halacha is supposed to be determined by the bezdin, not by the attorneys, not by the parties. The bezdin has to gather the facts. The bezdin then determines what the halacha is based upon its knowledge of Shulchan Aruch and Minhag HaMedina, etc., etc. There are various considerations that it reaches. And yes, I should mention, and our rules and procedures, also get your hands on that, we encourage what's called Pshara Krova Ladin, which means not 100%, not to 0%. That may be the strict halacha, 100 to 0. But we also factor in considerations of equity, what we call in our language yosher. There's din, and there's the fnim mishur din, which is yosher. Asisa yosher v'tov, said Rashi and Chazal, the fnim mishur din. So we do take into account, not as some people think, pshara means 50-50. Nothing, it's not correct. Pshara could be 100-0. If one party is right legally, morally, ethically, he gets 100%. But in many cases, it's not that way. And the Pshara Krova Ladin can often take off as much as a third to the party based upon the equity consideration. Even though it's strict halacha, you might not have a winning case. Again, not so specific, but we always encourage Pshara HaKrova Ladin as it's found in the classical Sfara. Okay. Now, what happens? A person went to a bezdin and he lost. He lost. So if he went to a bezdin and he suspects, and he can therefore prove ex parte communication took place, notwithstanding his protest against it, if he can prove it, then he can complain. Complain to whom? The problem is no other bezdins, I don't think, is going to invalidate the case. We have a principle, Beidina basa Beidina lo daiki. One bezdin does not re-examine a different bezdin, as a general rule. There may be recourse to secular court. A bezdin may tell such a fellow, listen, we don't know the case, but if you can try to prove ex parte communication to invalidate the results, which a court will likely do if, in their view, the ex parte communication influenced the case, then I believe it's permissible, and a rabbi can allow it, the bezdin should allow it in such circumstances. Again, it's not lechatchila in the first place, but this is a story. It's important. But aside from those situations, you win or lose, you accept it. We believe that HaKadosh Baruch Hu helps out Batei Din. There's a certain siyata d'shmaya. And as I said before, they're the only neutral parties. Certainly in our bezdin, they're neutral with no conflict of interest, no connection to either party. And if you lost, you lost. In our bezdin, it's unique again in this country. We have an internal appeals process. You can appeal to the manal of the bezdin. He will assign the case to one of the, we'll call them senior dayanim. I guess by now I'm pretty senior myself, but those who are younger than me are also senior, and they will hear the cases if the appeals are given, and they will decide whatever they decide, and that's the final decision. They will often just simply reaffirm what the initial bezdin said, because, as you know, in appeals, we're not supposed to deal with the facts. People spend hours and hours of bezdin time. A guy walks in from the outside. It's primarily to discuss certain procedural issues and certain simple mistakes. That's where the bezdin comes in for irur, for an appeal. I've had cases in which I changed things around a little bit from the original decision, and that was it. One of those cases, the person, we're not going into details, two sides both appealed. They both thought the decision was wrong. And one wanted 10 times as much money, and one wanted no money. And I ruled in the appeal, no money. That's when the person ran to the court in Maryland and said it's an irrational decision. And the judge said, no, it's very rational, it's very true. And therefore, that was fine. We've had cases in our bezdin where people tried to undo the case in secular court. There was one famous case with an employment issue, and we ruled in a very rare ruling that the employee must be reinstated because the grounds of his dismissal were simply too weak. And then, not into details, the school wished to undo our decision in secular court, and the lower court, in fact, did and overruled us. At that moment in time, the entire bezdin system in America shook, because if a judge can summarily overturn psak of 3 honest rabbis in an employment case, then despite the fact there was a valid star biru and doctrine of arbitration, so then nothing is binding. Luckily, the problem, that person that a lawyer was less than talented. We got some very talented people to work pro bono, and it was moved to the higher division of appeal. It was a 5-court panel in Albany, I believe, and they ruled 5-0 in favor of the bezdin, that the other lower judge had made a big mistake by trying to overturn it. This made bezdin even stronger in New York State. At the end of the day, we got a very, very strong vote of confidence that we got it right. Okay, a number of few more points I want to end, if there'll be time for questions perhaps later on. Sometimes a person will get an injunction from a particular court. We call it an equal. And some bezdin somewhere will make an equal injunction. You can't do this, you can't do that. Now, he has no authority. You don't know who he is. He's not the bezdin in your town. If, in fact, it's a reputable bezdin, then the rabbi should tell the balabas, you should listen to what the bezdin says. It's a reputable bezdin, and you should follow the injunction. But if it's just a trigger-happy bezdin that issues injunctions without proper recourse, without proper investigation, just because somebody said something somewhere and there's no basis for it in reality, you're allowed to tell the balabas it's not binding. And if they'll put a siruv against you for violating the injunction, so what? They have no jurisdiction. Keep that in mind. But the last thing I want to talk about is perhaps the most sensitive. I saved it for last. What happens if the rabbi himself is taken to a bezdin? It's been known to happen. They take the rabbi to a bezdin. The Gemara speaks about it. The Gemara in Masechet Sanhedrin, Dayan Shator, the rabbi made a mistake. So in olden days, when there was a certain kind of a hierarchy, the Dayan could be taken to a higher bezdin, and the higher bezdin says, "My dear Dayan, you made a mistake," and if as a result of that mistake, the person that for whom you ruled, that his cow was a treifa, and he really wasn't a treifa, so then you made a mistake and you're liable in certain situations. That system, however, does not apply nowadays. We have no hierarchy. It's hard to imagine that such a situation can be imposed on a rabbi against his will to force him to pay for he paskin a pot is treif. It turns out the pot was kosher. And he threw out the pot in the interim. It costs $50. It's hard to imagine a case in which the dayan, the rabbi, will be convinced 100% that he made a mistake in the kashrus matter. If he did make a mistake, he should pay the money on his own. He made a mistake, an honest mistake. You should always try to correct. But that it should be imposed upon you by some other body. Who says that body is more knowledgeable than you are? We don't know. And therefore, that model, although it's found in the Gemara and the Shulchan Aruch Simon Chaf Hei at great length, is likely not applicable in today's circumstances. However, there are cases in which the rabbi or a group of rabbis could be sued, not on grounds of religious decisions, it's kosher, it's not kosher, but rather on purely financial grounds. Financial grounds. The rabbi is the rabbi of a shul, and someone was fired, and they want to know, was he fired legitimately or not? Or there could be a question of a situation where rabbis are giving supervision, something called hasagas kavul, unfair competition. That's a purely monetary matter, and if a rabbi takes a position, in theory, that could be questioned by a different bezdin in certain cases. However, I want to hasten to add that if it's primarily a religious matter, even though it has financial ramifications, it does not belong in a bezdin. Rabbi's purview is to issue religious decisions. If the rabbi, makes a pat treif, and someone will then sue the rabbi in a bezdin, that bezdin should be told to not issue a summons. They want to talk to the rabbi. If he admits to his mistake, he should pay for it, but otherwise not. Otherwise, it's really sort of endless. Because if a bezdin will summon a rabbi, the rabbi can summon back the bezdin, and just go on forever. It's important to know, and this extends beyond rabbis. Some of the rabbis on the call may also have positions in schools, and in school there could be different kinds of issues. There could be a tuition issue, purely financial, that could come to a bezdin. But there's some other issues which are fundamentally religious issues, educational issues. For example, a school expels a student, so the father will take him to a bezdin. A bezdin shouldn't be hearing such cases. It's not the principal is hired to exercise his authority, these decisions. It's not the place of a bezdin to intervene. It's important to understand this. They should not be intervening if a group of rabbis decides that a certain eatery is substandard and kashrus. It's their obligation to say so. And if a bezdin is asked to take him to a din Torah, they should refuse. It doesn't belong. It doesn't belong. So you'll say rabbis are infallible? They're not infallible. They're not infallible. There is what we call, pardon the reference in this case, a quote higher authority. Yes, there could be a higher authority. If you look at the Sefer Chinuch in Parashat Shoftim, Osasu Yaman Usmol, for the Gedolim of the generation. And therefore, any rabbi or group of rabbis that says something in the field of kashrus and someone thinks it's inappropriate, their recourse is to find someone who is a recognized gadol, not just recognized by you, recognized by the rabbi or the group of rabbis as well, as someone who is peerless, someone who has a very high standing in everybody's eyes. And then if he tells the rabbi, the local rabbis, you made a mistake, I think you should do something differently, it's in their best interest and halachically proper to follow what this great rabbi says if they can be convinced by him, even though it means they say they made a mistake. There's nothing wrong with making a mistake. Everyone makes mistakes. But only then. It doesn't work because some bezdin, some rabbi decides to summon a rabbi or a group of rabbis to a Torah over, which is fundamentally a religious issue. That's simply inappropriate. And therefore the result is you shouldn't get involved. Yes, it's true. It's best that may slap a siruv on you. Okay, can't help it. As I said before, in some cases, you just have to take it. But I would tell people not to honor such a siruv, because the rabbis had the right and the responsibility to rule on kashrus matters, or a principle to rule on student acceptances matters. That's not everything belongs to the bezdin. I just want to close with my time, as I understand it, is up. That the importance of bezdin is so critical. Happily, the bezdin of America has been serving in its reconstituted form for nearly a quarter of a century, and we may have made mistakes. No, I said before, "Ein l'dayin l'mashen avroas," the Gemara says. Everyone makes mistakes. We're all human, but to my knowledge, we've never been accused of dishonesty in terms of fraud, bribery, ex parte. These things have not happened to my knowledge even once in all these years, which is a good sign. I'm happy to report that even beyond our own bezdin, there's been thank God, as part of the explosion of the we'll call the strictly Orthodox population in our parts, there have been some new Batei Din, a couple of them in Lakewood, New Jersey, which is the center of this explosion. They're very reputable, very professional, and therefore, if someone is asked to go to a bezdin other than our own, I'm not permitted to make any formal recommendations, but I'm not naming any names. But I'm happy to report the phenomenon that did not exist 25 years ago when we began our reconstitution, and now it exists. One, I think, started about 15, 20 years ago, one about 10, 12 years ago. Both very, very good, and not entirely unrelated to our part of the world. We'll leave it at that without being more specific. Individuals from our sphere that have gravitated there, they're top-notch in many, many ways. I want to thank you for listening. We have to pray, as we do every single day. Hashiva Shavtenu Kivarishona V'Yotzenu Kivatchila. Kadosh Baruch Hu should fulfill the Tzion b'Mishpat Tipada b'Shaveh b'Staka b'Mheira v'Yameinu Amen.
Thank you very, very much. Appreciate it.
I have time for questions if someone wants to ask a question.
Okay, the floor is open.
Rabbi, if somebody sends a hazmana from one bezdin, whether it's an ad hoc bezdin or a sitting bezdin, and somebody wants to avoid a zabla, but someone does not want to feel that the bezdin that sent the hazmana is someone that someone has any kesher with, or how does one deal with the situation if you get hazmana and you do not want to go to that particular bezdin? You want to go to a different bezdin.
As I mentioned to you before, I'll say it again. If a person in your synagogue is called to a different bezdin, ask him to respond to that bezdin by saying he wants to go to the bezdin of America. You're a member of the RCA. This is your bezdin, and that's where you want your person to go. That's it.
And if he doesn't?
Okay. If he doesn't. So then you have every right he won't go to your bezdin, you won't go to his bezdin. This is what we call zabla. Yeah. Zabla, in theory, is great when it works. The unfortunate reality is that often, I'm not saying always, often it does not work. Sometimes because the system is corrupted by Toanim. Sometimes because even the borer is taking money on the side with ex parte, which renders him invalid, in my opinion, and therefore you're stuck. So you should try to avoid Zabla if the other parties are not a sterling character. At the end of the day, we should go to Zabla. At the end of the day, if the other party insists on choosing one person whom you do not trust, and that person insists on the third one being someone in his camp that you also don't trust, just refuse to go. There'll be a seer against you. You'll have to swallow it. There's nothing to do. You can't go to such a bet. You just can't go. It's just wrong. I have to tell you that one of the things that impelled me to become more active, actually two things impelled me to become active in the Bezdin of America when it was reconstituted in the late 90s. One was I was involved in two, we'll call them Aguna cases I was pulled into. It was the same year, 1997, it was the same month, it was the month of June. And I saw some of the underside of the world with Toanim and with people taking money on the side. I said, this is not right. We have to have a much more professional, competent, honest alternative. Number two, I was involved in a case which was in fact honest people. A Zabla, 3 honest people. Everyone was honest, but they had a different view of the world. They viewed the world as being judged purely by Shulchan Aruch. Whereas I view the world, and that's how our Bezdin still to this day views the world, as saying, sure, the Shulchan Aruch decides all matters which are pure halacha. But whenever there's a question of what we'll call the meeting of the minds, when there was an agreement between two parties, you have to look at what they had in mind, and not what they have in mind now, what they had in mind then. I'll give a particular case which I was involved in. There was a certain situation, I think it was something called title insurance, a long time ago, in the 90s. And I got involved in this Zabla. Everyone was honest. And I said, wait a second. This fellow who does the insurance, he deals with all kinds of people, Jews, non-Jews, from Jews, non-from Jews. And every time there's a dispute, we know it's governed by secular law and a secular court. And that's exactly why the document is drafted by lawyers, attorneys, because they know secular law. Just so happens in one case, the other side happened to be an Orthodox Jew. So he decided, this is a fellow from we'll leave it this way. There were 2 clean-shaven men from young Israels that were involved in the dispute, but the other party decided to go to a Bezdin in Borough Park. Why did they go to Borough Park? Okay, honest person in Borough Park, really. But they viewed the world differently. They couldn't understand why it's possible to veer from what the Shulchan Aruch says, because it was clear that they had in mind the law. If they had in mind the halacha, they should have asked rabbis to draft it. Why they asked lawyers to draft it? Seeing this nature impelled me to get involved in our Bezdin, which we've been involved in now for, let's say, almost a quarter of a century. But again, we can't control everybody or everything. You have to roll with the punches in such situations. Any more questions?
I have a question. I'm involved with a conversion case in which every Bezdin says the halacha is exactly as they say, but we are more machmer today. How should I understand them saying, but we are more machmer today?
I wish I could comment on that. My session does not discuss conversions, although our Bezdin does handle conversions. I think we handle them quite well. There are other Bezdins that are more lenient, other Bezdins that are more strict, but the statement that you're quoting, you'll have to contact me privately. I'll try to respond to it. Any other questions?
Thank you.
You're welcome.
Rabbi Willie, could you just clarify? You said there are times when a siruv can be ignored. How do we go about making that decision? And doesn't that undermine the whole concept, the whole institution of siruv, if people can then second guess the Bezdin that issued the siruv?
It depends who the Bezdin is. Depends on the Bezdin, depends on the circumstance of the case. In other words, a siruv, there are 2 ways in which the rabbi will not enforce a siruv. One case is where there's a bezdin of ill repute that issues a siruv. I'll give an example. In our bezdin, if someone else, the plaintiff came to us, and the defendant goes to another bezdin, all right? And then back and forth, at the end of the day, gets nowhere. We will never issue a siruv in such a case, unless he goes to a bezdin that's so egregious, that's such a thieves, that's a possible exception. Other batei din are not so benign. In such a circumstance, they'll issue a siruv against somebody who was willing to come to our bezdin, but they couldn't agree with his ablaw, so they'll issue a siruv against him. I don't think that siruv is valid. I'm not undermining bezdin. I'm undermining a particular bezdin that doesn't agree that a person has a right to come to the bezdin of America and have an honest ablaw. That's one kind of a case. A second kind of a case is, no, the bezdin issued a siruv, and the bezdin is right. The bezdin is right, and the person in my synagogue is wrong. It's wrong. But how strictly I enforce it depends on the personal circumstances. Maybe the person has no money, the Kool-Aid. Even though technically speaking he owes the money, doesn't want to. In a case, he didn't want to come to bezdin personally. He wanted to come with his company, and the bezdin ruled that's not a valid response. The bezdin is probably right, but at the end of the day, the guy has no money. I'm raising money to help pay for his kids' food, and I'm going to start enforcing a siruv. That's also something which is very difficult to enforce in that circle. We had a couple of cases, wild. A case in which the individual who was placed in a siruv was not we'll call it the balabas. It was his wife. His wife is placed in siruv by our bezdin. Long story, not for now. This goes back more than 10 years. And what to do? So I consulted with a few of my senior colleagues, and they had two opposite positions. One said, come on, it's a smokescreen. It's the wife and husband, it's all one. So he said, on that he was strict. On the other hand, he said, there's not much you can do about it because we don't do these things anymore. We don't say you shouldn't go to his house anymore. You shouldn't invite him to. We don't do these things. Other senior rabbis said exactly the opposite. No, technically speaking, it's only the wife. But you have a right to say, maybe you should say, because the wife is misareves, no one should invite them, no one should talk to them, da-da-da-da. Had two opposite senior rabbis telling me the opposite things. These are all case-by-case situations. Any other questions?
Yes.
Yeah, when do you said that the kashrut organization or the people suing the kashrut organization shouldn't go to a beit-din. If they have disagreements, as I'm not sure what you're referring to, but let's just say they have a business disagreement, the beit-din is put by condemning their kashrut because they went to a different organization, is suddenly no good. So why wouldn't that be brought to the beit-din?
I repeat, you have a funny case. Just imagine, and we'll talk in the language of Luya Tsuya. Just imagine a hypothetical. You have a rabbinical organization who's in charge of kashrus, has 50, 70 rabbis on it, okay? And they reach the judgment with their expert, who's recognized in the field as one of the best experts in the entire country. There's certain situations substandard. Based on whatever is, they threw out the mashkiach, they caught him with something, there's a whole bunch of serious things could have happened, okay? And then this fellow decides to, his kashrus was not given, it was removed. He'll go to a different organization, and the rabbis in the field feel that the other organization is substandard. They know the fellow cheated on them. They know the fellow didn't act properly. So they make a statement that this does not meet our standards of supervision. Good. Now the guy says, "Would it affect me financially?" Of course it did. So we'll say it's a purely financial matter, belongs in a bezdin. Wrong. It's not a financial matter. It's a matter of kashrus, which has financial implications. So you'll say, this group of rabbis is beyond reproach. No one can touch them. Nobody. That's what I said before. No one is beyond reproach. Fine. The senior great rabbis, whether it be here or in Eretz Yisrael, they're all great rabbis, are peerless, and say, listen, I don't want to listen to you. we have to go to that rabbi, that organization. I think that no matter how great the rabbi or rabbis are, they should accede to that wish and explain to the other party what they think. And if the other rabbi says, the peerless rabbi says, I think you're wrong and you should retract, I think they should retract. But it's based on their voluntarily going there. We have no official hierarchy. This is no longer, it used to be in the, in the time of the Gemara. We don't have that anymore. That's what I think. Any final question? I'm supposed to end by 3:00, the latest.
The Willard, do you have a moment? Daniel Kramer Shakoch. Just before I ask my question, just one thought that I don't know if you know. There was an article in yesterday's New York Post about a tremendous sichsuch between kashrus organizations.
I will not comment on any articles. What's your question, please?
Okay. In terms of Avkos Kedushin, what is the Bezdin's
Avkos Kedushin? I have 2 minutes to go. Here's my Avkos Kedushin, Rabbi. That's not really fair. The default position is that Avkos Kedushin does not exist. That's a default position.
Okay.
There could be very, very rare exceptions. Unfortunately, and it's not my topic for today, there are other so-called Batei Din with grandiose names, very grandiose, with unfortunately are not doing what they should be doing. They're doing things that are terrible and could lead to very serious halachic consequences, much worse than with anything we spoke today about money, talking about you know what I mean, adultery and mamzerus. Anything can happen based on these rulings, and these places should not be frequented at all. Thank you very much for listening, Rabbi Osai, and we should all be zocha to the Gula Shleba Meher V'Yameinu. Amen.
Amen. Thank you so very much.
Thank you.
Thank you.